A three-judge bench headed by Justice Arun Mishra ruled that a Hindu woman has the right to be an heir to the ancestral property. The verdict states that the right is by birth and does not depend on whether the father was alive when the law was enacted in 2005. The Hindu Succession Act 1956 only recognized males as legal heirs. According to legal experts, it settles the ambiguity surrounding the nature and extent of a daughter's rights in a Hindu undivided family property. Experts also call it a progressive step towards equal rights, as the apex court has settled that as long as the daughter is alive post 2005, she has an equal right as a son in the co-parcenary property. Therefore, it is irrelevant that her father was alive or not on the cut-off date of September 9, 2005. Sonam Chandwani, managing partner at KS Legal and Associates, has said that the verdict settled a disputed question of law. She said this clarification was vital in setting aside the grip on previous decisions accorded co-parcenary rights to daughters only if both father and daughter were alive, as on September 9, 2005, when the amendment was notified. Calling the judgment a welcome move, Rahul Arora, partner, Tri-Legal, said the ruling aids the society at large in moving towards a more sensible conclusion and breaks free from deadlock of the dated patriarchal system. The ruling is important for various reasons. One, it sets to rest whether partitions which were undertaken before the 2005 amendment can be reopened by the daughter. If a partition has taken place before 2005, it cannot be reopened if the legal process has been followed. The judgment also states that in this context, an oral partition is not a statutorily recognized mode of partition, and the same can be accepted only in exceptional cases or if it is backed by public documents or affected by a decree of a court. This ensures that daughters' consent or rights are not taken away. Some states had made the amendment before the Supreme Court order. Kerala had abolished the Hindu joint family system in 1975. One issue which is still open and is a matter of legal debate is whether the lineal descendants of a daughter partake the same rights as the lineal descendants of a son, points out Bijal Ajinkya of Khaitan and Company. The Supreme Court order eliminates all challenges except for assets divided on or before the cut-off date of December 20th, 2004. The law applies to ancestral property and succession in the personal property where succession is as per law and there is no will. The apex court has also directed high courts to dispose of cases on these lines within 6 months.